in the chapter that was titled Offense Against Human Body. That would be chapter 16 of Indian Penal Code, and then a few offenses in other chapters. For example, the offense of cruelty against married women, section 498 capital A, that was in a separate chapter, having just one section, which was added quite late as part of Indian Penal Code. And then another offense which we are all aware of, informally called the offense of e-teasing, that was in another chapter, that was section 509 of Indian Penal Code. Then under the Bharatiya Nyaya Sanhita, you have the same classification in the sense that the same scheme that was followed by the Indian Penal Code, that in certain chapters there would be general provisions, general principles, including principles related to abetment, criminal conspiracy, attempt, and in the other part there would be substantive offenses. So again, remember and recall, the first chapter on substantive offenses in the Indian Penal Code was titled Offense Against the State, and that would start from section 121 of Indian Penal Code. And the first chapter on substantive offenses in the Bharatiya Nyaya Sanhita is titled Offense Against Woman and Child. And it starts from section 63, defining the offense of rape, and then moving on to other offenses. So often this is raised an issue that is this placement of any significance? And the answer has to be in an emphatic yes, that this placement is of great significance, because the Indian Penal Code was drafted, was enacted, was enforced by colonial powers. And that colonial power would genuinely be interested in its own protection. And that was reflected in the sequencing of chapters, where the first chapter on substantive offenses would be titled and styled as Offense Against the State, starting with waging war against Queen, as it was then, and then later waging war against government of India after independence and all. But then there is another view that protection of the state should be the topmost priority. Why protection of the state itself should be accorded topmost priority is because only a safe, stable, prosperous state would be in a position to protect its constituents. You can't expect the same degree, extent of protection to life, liberty, property of an individual in a state which is unstable, which is fighting internal, external forces, and its own existence is in constant peril. So this is another view, but still placing chapter on offense against women and children, and according it, the topmost priority reflects on the changing thoughts as far as the policy makers, the legislature, the executive is concerned. And that is how I would also like to view this change. So coming to offenses against women and children, you would find that it's chapter 5 of Bharatiya Nyaya Sanhita, which I said, and I must repeat, that is the first chapter on specific offenses. To be precise, the Bharatiya Nyaya Sanhita from sections 63 to 99 deals with the variety of offenses against women and children. As far as the definition of a woman is concerned, Bharatiya Nyaya Sanhita retains the same definition that we had in the IPC, that is, a female of any age. So a just born female would be, for the purpose of Bharatiya Nyaya Sanhita, a woman, as much as an adult woman would be. But what is new as far as Bharatiya Nyaya Sanhita is concerned is that though the word child would appear at several places in several offenses in the Indian Penal Code, but for the purpose of Indian Penal Code, no threshold, no age threshold was prescribed. And you are aware that how different provisions in the Indian Penal Code would prescribe differential age threshold for children of the two gender, male and female. One example would be that the offense of kidnapping from lawful guardianship. You may remember that the definition would provide that the offense can be committed only when a male child is under age of 16 years and a female child is under the age of 18 years. Now, this differential age threshold was problematic because India became signatory to that United Nations Convention on Rights of Child, that convention of 1989. India endorsed it in 1991-92 and was under an obligation to fine-tune its laws, including penal laws. And the obligation included the obligation to prescribe a uniform age threshold for all genders. So now the Bharatiya Nyaya Sanhita has a new definition of child in section 2, clause 3 of Bharatiya Nyaya Sanhita, which means a person who has not completed 18 years of age. Now, this definition is in complete sync with the definition of child in certain other child-centric legislations, especially the Juvenile Justice, Care and Protection of Children Act of 2015 and also the POCSO Act of 2012, both in the JJ Act of 2015 as well as in POCSO Act of 2012. A child means child of any gender, a person of any gender who has not completed 18 years of age. So now, even the general penal law of the land, that is the Bharatiya Nyaya Sanhita, contains this definition of child, which is completely in sync with the international law as well as the other municipal laws, domestic laws. Another very important change, probably that change must have been underlined in the previous session, is that how gender is no longer to be understood as a binary, that it only refers to either a man, a male, or a female. The definition of gender in the Bharatiya Nyaya Sanhita now specifically mentions that it would also include a transgender as defined in the Transgender Persons Protection of Rights Act of 2019. So for the definition of transgender, the Bharatiya Nyaya Sanhita refers back to that Transgender Persons Protection of Rights Act of 2019, but it's now amply clear that the IPC provisions which would use either a man or a woman as the only two genders, now the Bharatiya Nyaya Sanhita refers to not only a man, a woman, but also a transgender. Now coming to the scheme of Bharatiya Nyaya Sanhita as far as offense against women and children are concerned, the first offense in that chapter is the offense of rape. Offense of rape underwent significant changes in 2013, as you all are aware, when in the aftermath of Nirbhaya gang rape in December 2012, several sweeping changes, even in the definition, were made in several provisions of Indian Penal Code, and also changes in the procedural law, CRPC, and then in the law of evidence, the Indian Evidence Act, were also effected. So Bharatiya Nyaya Sanhita in section 63 defines the offense of rape and retains the same definition, with only difference that now in exception 2, the age that was previously mentioned as 15 years has now been substituted with 18 years. Now this is again a significant change. Significant in the sense that in a 2017 judgment, Independent Thought versus Union of India, the Supreme Court had read down exception 2 of section 375, where this age threshold was 15 years, and had substituted in 2017 itself that with 18 years. However, no corresponding amendments were made in the then existing Indian Penal Code, and the position remained a little problematic in the sense that, of course, the way we, the students of law and the legal fraternity, knows the case law and its impact, certainly other players of the criminal justice system may not be knowing. So this was long due and was rightly made when BNS replaced the Indian Penal Code. Other than that, there is no change in the definition. That also means that the marital rape exemption that husbands in India have always enjoyed, provided that the wife is above the age of 15 years, still Independent Thought, and now 18 years after independent thought and these changes would continue. You may also be knowing that in a challenge to this exception 2, the Delhi High Court had returned a split verdict. A division bench of Delhi High Court had returned a split verdict. And the matter is now pending before the Supreme Court of India, where several petitions were clubbed together, all having one common issue, that whether exception 2 is violative of Article 14 and Article 21 of the Constitution and must be struck down. So we are awaiting the judgment of the Supreme Court on that issue. But till then, as I said, that if the wife is above the age of 18 years, her consent is of no avail, or absence of it is of no avail, and no criminal liability for husbands for the offense of rape. As far as punishment for the offense of rape is concerned, that is now in section 64 of Bharatiya Nyaya Sanhita, and there are no changes. However, I would draw the attention of the participants to one incongruity as far as the language of section 64 is concerned. And that incongruity has only continued from at least 2013. What is that incongruity? And you may be tempted to read even the language of section 64 clause 1, which corresponds with section 376 clause 1. Now you know that the minimum punishment that would be awarded in every case of rape is now 10 years imprisonment. But what would be that nature of imprisonment of 10 years, which is the minimum sentence? Would that be simple imprisonment? Would that be rigorous imprisonment? Section 64 reads rigorous imprisonment of either type. Rigorous imprisonment can't be of either kind. Rigorous imprisonment is imprisonment with hard labor. It can't be without labor. So whenever the punishment prescribed is rigorous imprisonment, it's understood as imprisonment with hard labor. There's no other option available anyway. Then, as far as the punishment part is concerned, there are minor changes in punishments of aggravated forms of rape. For example, section 65 clause 1 of Bharatiya Nyaya Sanhita prescribes punishment for rape of a woman under 16 years of age, and section 65(2) for rape of a woman under 12 years of age, which may now attract even death penalty. And this section 65 of Bharatiya Nyaya Sanhita is a combination of section 376 clause 3 and section 376AB of Indian Penal Code. Section 376AB was added only in 2018, as you are aware. Other than these changes in the penal policy, there's no significant change as far as the definition is concerned. However, a new offense of sexual intercourse by employing deceitful means has been added to the scheme of Bharatiya Nyaya Sanhita. And that is by section 69 of Bharatiya Nyaya Sanhita. This new offense of sexual intercourse carries the maximum punishment of 10 years imprisonment. And the deceitful means include inducement for or false promise of employment, promotion, or marrying by suppressing identity. The language in which section 69 is couched that may raise many issues whenever cases are before the constitutional courts, the high courts, and the Supreme Court. I must emphasize here that sexual intercourse by employing deceitful means, especially on account of a false promise of marriage, has given many anxious moments to the constitutional courts. I remember that way back in 1984, probably for the first time, Calcutta High Court in Jayanti Rani Panda versus State of West Bengal was confronted with this question, that whether a promise of marriage which was extended by a man and believing that promise, a woman consented to have sexual intercourse, and later, if the promise is broken, not kept, would that sexual intercourse amount to the offense of rape? Though in that particular case in Jayanti Rani Panda versus State of West Bengal, the Calcutta High Court had ruled that in the peculiar facts and circumstances of the case, the accused would not be liable for the offense of rape. But then there have been plenty of decisions, a lot of decisions of the Supreme Court and also of the different high courts answering this question differently. You may be aware of Uday versus State of Karnataka, that 2003 decision where the Supreme Court had held that a false promise is not a fact for the purpose of Indian Penal Code. Then another important decision of 2005, Dilip Singh versus State of Bihar, where the Supreme Court again considered that whether false promise would qualify as misconception of fact. You are aware that a consent given under misconception of fact is no consent in the eye of law. And one who acts on such a consent given on account of a misconception of fact does so at his own risk and may be liable for the harm caused. the injury is caused. So prior to coming into force of Bharatiya Nyaya Sanhita, cases of false promise, employing of deceitful means in obtaining consent to have sexual intercourse, they would all be dealt under the rape provision. And the court would only be looking into that whether the consent was free or whether the consent was vitiated, whether it was a misconception of fact or it was not. But now on, from July 1, 2024, such cases of broken promise of marriage, cases where deceitful means, which would include a false promise of employment, false promise of promotion, would be dealt squarely under section 69 of Bharatiya Nyaya Sanhita. But it doesn't mean that there can't be a rape charge if there was a romantic relationship. This is something which must be kept in mind. In a romantic relationship, in an otherwise apparently consensual relationship, there may be a charge of rape. And section 69 makes it very clear. Section 69 says that section 69 is explicit that the first and foremost condition for its application is that the doesn't fall to be punished if the key elements are present, including that there was a false promise. As far as false promise is concerned, the Supreme Court has been very categorical that a false promise is a promise which was false right from the very inception when it was made, having no intent whatsoever of fulfilling that particular promise, which was a complete hoax. And in a catena of cases, the Supreme Court has also differentiated between a false promise, which may lead to criminal liability, and a mere breach of promise, which the Supreme Court said that would not lead to any penal liability. And the objective criteria which the Supreme Court had in those cases, which are being consistently followed, and I believe that in determination of this question, that whether the accused is guilty under section 69 of Bharatiya Nyaya Sanhita or not, the same principle, the same objective criteria would be employed, that being, and I must repeat, that a promise can be said to be a false promise only when there is evidence to suggest that right from the very inception, at the moment of making that promise, the accused had no intentions whatsoever of keeping his words. However, it may be that at the time of making that promise, the accused very much intended to keep his words, but due to certain circumstances beyond his control, which he could not have foreseen, he was unable to. And that would be a case of a mere breach of promise, not leading to any penal liability. So under section 69 as well, it has to be proved by the prosecution that it was a case of false promise on the same principles which would apply previously to determine whether it was a case falling under the definition of rape or not. Now, another very important and interesting aspect of section 69 is that it would punish a man who, by suppressing his identity, marries a woman. Now, see, there are two circumstances in which Section 69 would apply. Two entirely distinct circumstances. One is where a promise of marriage, promise of employment, promise of promotion was made, was not kept, and on account of such a promise, consent was obtained, sexual intercourse took place, punishable under Section 69. It would still be an offense under Section 69 if a man induced a woman to marry him by suppressing his identity. So in the first class of cases, there was no marriage at all. That's why prosecution. But in the second class of cases, there may be a marriage between the man and the woman, the accused and the woman. But later, after marriage, the woman discovered that she was strict to marry this man because this man hid certain vital identity details of his. So you can assume and understand that how and in what circumstances Section 69 would be invoked, even when the accused has married the woman, the girl. So suppressing one's religion, suppressing one's caste, you may be wondering that in a modern society, whether suppressing caste would be suppressing identity. Yes. Suppressing one's religion would be suppressing one's identity. Even marital status. So other than that offense of bigamy which a person may be charged with, a person suppressing his marital status would be suppressing one of his very vital aspect of identity. Even employment status may be brought into Section 69 as related to suppression of identity. Then Section 70 of Bharatiya Nyaya Sanhita, it punishes the offense of gang rape, and unlike Indian Penal Code, where the offense of gang rape and certain aggravated forms of gang rape were dealt in separate sections, Section 376D, Section 376D-A, and Section 376D-B. Section 70 of BNS unifies these three independently existing IPC provisions. But then the definition elements of gang rape have not been changed. And another key change is that punishment for gang rape of female child. That means a female child under the age of 18 years may be death penalty now. Whereas under the IPC, death penalty was prescribed for gang rape only when the girl child was under 12 years of age. Then section 71 of Bharatiya Nyaya Sanhita corresponds with section 76 capital E of IPC, which would punish repeat offenders of these sexual offences. Then you have section 72 and section 73, which correspond to section 228 capital A of Indian Penal Code. Remember, disclosure of identity of victim of rape. Disclosure of identity of victim of rape. Then the Bharatiya Nyaya Sanhita also includes the other IPC offences, and in almost the same sequencing. For example, section 74 of Bharatiya Nyaya Sanhita, that punishes the offence of outraging modesty of woman, which was previously punished under section 354 of IPC, which again was amended in 2013, as you know, and carries no changes. Section 75 of BNS corresponds with section 354 capital A, which is the offence of sexual harassment, and has no change in definition or punishment. Section 76 of Bharatiya Nyaya Sanhita is the offence of disrobing a woman, that was under IPC section 354 capital B. However, now under the BNS, that is section 76 of BNS, any person, including a transgender, may be accused. That was not the case under the IPC. This is very significant. So a man disrobing a woman or compelling her to disrobe herself or abetting another to disrobe her, a transgender doing the same, a man, of course, doing that act or abetting it, would all be punished thanks to this key change, where the word man, as it occurred in section 354 capital B of IPC, the word whoever has been used in section 76 of BNS. Similarly, the offence of voyeurism, which was again introduced in 2013 by adding section 354 capital C, it also previously punished only a man watching or clicking or capturing the image and transmitting it, while the woman is engaged in certain private acts at a place where she has a reasonable expectation of privacy. Now, a man, a woman, and a transgender doing that, which has been made punishable, would be liable. But then, section 78 of BNS, which is the offence of stalking, and corresponds with section 354 capital D, again, which was added in 2013, would punish only when the stalking is by a man. So a woman is stalking another woman, a transgender stalking another woman would not be an offence under even the Bharatiya Nyaya Sanhita, only when a man stalks a woman. And that stalking is not limited to physical stalking. Rather, that stalking extends to stalking in cyberspace as well. You are aware, and I need not elaborate that, how all of us spend a lot of time in the cyberspace doing all sort of activities from recreational to educational and other activities. And there is always this fear of being stalked. So that stalking provision of section 78 or even that stalking provision of Indian Penal Code section 354 capital D would have extended to stalking even in cyberspace. However, what is very important in this regard is that stalking is repeatedly following to the annoyance of the victim. Repeatedly means more than once. So simply following a woman in cyberspace or in physical space and trying to force a conversation only once, which is refused, may be some other offense, but certainly that is not a stalking unless and until it is repeated another time at least. So the word repeatedly occurring in section 78 and it also occurred in section 354 capital D is of a great significance, where of course one time following a woman in physical space or in cyberspace would not be punishable. Voyeurism, I told you, punishes again persons of all gender. However, stalking punishes only a man and not a woman. So just to repeat, for sake of convenience and better learning, outraging modesty, any person can commit. And that was the position right from 1860 itself, section 354, which is now section 74 BNS. Any person could have committed that offense. Any person can commit that offense. So it is possible that modesty of a woman is outraged by another woman. However, sexual harassment only by a man, disrobing by any person, irrespective of gender, voyeurism, any person, irrespective of gender, stalking, again only by a man. Other than these offenses, you would find that there are several other offenses included in this chapter which are not strictly speaking so, not offenses against women. I'll give you an example and then I'll proceed because we don't have much time and I would also like 5-7 minutes for a question and answer if organizers permit, of course, and that is part of the scheme for today. Bigamy. Imagine the offense of bigamy. And recall the definition of bigamy in section 494 of Indian Penal Code. Bigamy is an offense which the makers of Indian Penal Code perceived and considered to be an offense against the institution of marriage and not as against an individual. Ultimately, an individual would be affected, of course. But then, both a man and a woman can commit the offense of bigamy while remaining married. So, including bigamy in a chapter that is titled Offense Against Woman and Child, to my understanding, doesn't make sense. Another issue I must flag here, that when you see the scheme of Indian Penal Code, you would find The Indian Penal Code would first define what assault is, what criminal force is. Rather, first it would define the offense of criminal force. And then what is assault? For example, section 349 of IPC would define force, 350 of IPC would define criminal force, 351 of IPC would define assault, and 352 would punish criminal force or assault when directed against a person, of course. These offenses, 74, 75, they require criminal force or assault. There can't be an outraging modesty of a woman without there being a criminal force or assault. So first, anyone who is interested in learning the elements of these offenses must learn what criminal force and what assault is. And the difference is technical. The difference is technical. All of us believe that what's the big deal? Don't we all understand what assault is? But your generic idea of assault may not be of much help when it comes to answering a legal question. That too in the realm of Bharatiya Nyaya Sanhita, that whether it is assault or whether it is criminal force. Because there is a real distinction between the two. And if you see these sections of Bharatiya Nyaya Sanhita, which correspond with the sections of IPC which I just mentioned, 128 of BNS corresponds with 349 defining force, 129 of BNS corresponds with section 350 defining criminal force, 130 corresponds with section 351 defining assault. You'll find that how the makers of IPC had used very illuminating illustrations to mark the difference between criminal force and assault. So without understanding, you cannot understand these offenses against women which require either criminal force or assault. And that is how provisions were arranged in the Indian Penal Code. But then in the Bharatiya Nyaya Sanhita, offense of outraging modesty occurs at section 74, disrobing occurs at section 75, and you would find force, criminal force, and assault later at section 128, 129, 130, and that too in a distinct chapter altogether. That's a distinct chapter. That's a chapter which is titled Offense Against Human Body. These are offense against human body, no doubt. Assault is the most innocuous of all offense against human body, no doubt about it. But then its concept must be crystal clear as far as the application of these offenses are concerned. Then in the same chapter, that is chapter 5 of Bharatiya Nyaya Sanhita, you have several offenses against children, which were previously under different chapter, majorly under the chapter titled Offense Against Human Body. That chapter still remains. But this sequencing, this placement also raises several concerns. If I ask you today that don't you think that kidnapping from lawful guardianship is an offense against child? Kidnapping for the purpose of maiming, isn't that an offense against the child? Most of you would say yes, but you won't find these offenses in the chapter titled Offense Against Woman and Child. There are offenses against woman and child. There are offenses against child in this chapter, but then there are key exclusions. Not that they are not punishable under the BNS, but they have not been placed in chapter titled Offense Against Woman and Child. One reason may be that kidnapping is not considered to be an offense against the child. Rather, kidnapping is considered to be an offense against the lawful guardianship. It's an offense against the guardian, the lawful guardian. Maybe. But then certainly that affects abduction, at least, is an offense against a child. Because the child may not be in a person's guardianship. It may not be the case that the child has a guardian. But such child, though cannot be kidnapped because there is no guardianship, can still be abducted. And that abduction would be an offense against the child. But then, these are a few issues which I wanted you to understand, research on, think over, ponder over, and then try to find an answer for. Other than all the offenses that IPC would have with differential age threshold, the BNS maintains a uniform age threshold of 18 years in most offenses. However, the two exceptions. One I'll flag here, and the other I would like you to find. It in one of the provisions, which IPC also had, says that kidnapping a child for the purpose of stealing from the child's person is an offense only when the child is 10 years old. Kidnapping a child for the purpose of stealing from the child's person is an offense only when the child is 10 years old. That was the case under the IPC. That is the case under the BNS as well. There is no rationale. There is no rationale. International instruments, as I already mentioned, other domestic laws which deal with offense against children. For example, there is a complete chapter on offense against children in JJ Act of 2015, where there is no differential age threshold. No differential age threshold. Child is a child, and there is no sub classification based on age, except for a certain purpose in the JJ Act of 2015, which is another issue altogether. So an offense which was not part of the Indian Penal Code but is now in the BNS is Section 95, which is a new edition and punishes hiring, employing, or engaging a child to commit an offense. In recent past, several cases have been noticed where adult handlers would be engaging children. And when I say child, a person under the age of 18 years, I'm sure that you are aware that how in the recent killing of a politician in Maharashtra, which triggered large-scale outrage, and rightly so, was carried out by one who claimed that he is under the age of 18 years, and that led to verification of his age by ossification test and all. So such cases are not rare, where adult handlers would be engaging older children, though that's an informal word, say 17 and a half year old, only in order to avoid the rigors of the adult criminal justice system. Section 95 says that hiring, employing, or engaging a child to commit an offense is an offense in itself, with a minimum punishment of 3 years, which may go up to 10 years and fine. If the offense is committed by the child, the person hiring, employing, or engaging the child shall be punished with the punishment prescribed for the offense. The child may not be punishable for whatever reason. The child may not be. And then the few other changes which must be, though I've completed the allotted time probably, must be mentioned here briefly. For example, section 96 of BNS, which corresponds with section 366 capital A of IPC. Procuration of a child irrespective of gender now is punishable. Under section 96 of BNS, procuration of a child irrespective of gender is now punishable. Similarly, section 98 of BNS, which corresponds with section 372 of IPC, uses the word child, which again, as I said, that refers to a person under the age of 18 years. So these are a few important and key provisions and changes as far as the offense against women and children are concerned. If there are questions and few interventions come in.
So there is a question in the chat box. If you
Okay, all right. Let me open it. Okay. Is marital rape punishable under BNS? Marital rape is not punishable under BNS unless the wife is under the age of 18 years. Now, this is incongruity. Incongruity in the sense that the minimum age of marriage in India is for girls 18 years, but we know that still, despite making several strides, girl children in several parts of the country, they are being married off, though that is now only 23 to 25% of all girls in India. But then child marriage is a reality. The PCMA Act, on which the Supreme Court only yesterday delivered a judgment, does not declare a child marriage in null and void. In fact, child marriages are only voidable, and that too at the option of the party that was minor under the age of 18 years. So the position today is that if the wife is, say, 16 or 17 years old, and the husband has sexual intercourse with such a wife, that would certainly be punishable, not only under section 64, but also under the relevant provisions of the POCSO Act. But then, once the wife is above the age of 18 years, the husband is completely immune from criminal liability, even under the Bharatiya Nyaya Sanhita. Now, the question is that how does the Bharatiya Nyaya Sanhita address the burden of proof in cases involving offense against women and children? Bharatiya Nyaya Sanhita doesn't provide for any provision as far as burden of proof is concerned. As far as burden of proof is concerned, that is dealt exclusively under Bharatiya Sakshya Adhiniyam. I'll give you two examples. For example, for the offense of dowry debt, that is section 80 of Bharatiya Nyaya Sanhita, which corresponds with section 304 capital P Indian Penal Code. You have this reverse presumption which you had in Indian Evidence Act in form of section 113 capital A. Similar reverse presumption is there in Bharatiya Sakshya Adhiniyam. Probably in this course, when you would be discussing Bharatiya Sakshya Adhiniyam with other experts, you would have an opportunity to discuss that. Another example would be that section 114 capital A of Indian Evidence Act has also been retained in Bharatiya Sakshya Adhiniyam, which provides for presumption of absence of consent in offense of rape of an adult woman. So these are songs which are spreading hatred and outrageous modesty of women can be. Yes, certainly. Not hatred as such. The offense of insulting modesty. The offense of insulting modesty, which was previously dealt under section 509 of IPC, is now dealt under section 79 of Bharatiya Nyaya Sanhita. So the language is same. Any person who utters certain words, which would include singing a song, which would also include a whistling, making a gesture, exhibiting certain obscene object, and otherwise breaching the privacy of a woman would be punished. Yes, of course.
Sir, I think Paras also has a question. If you could take up his question as well. He has raised his hand.
Yes, please.
You can go ahead, Paras, if you have a question.
I'll also like to answer this question, which has been asked by someone who goes by the name Liquid Miracle. Anyway.
Absolutely, sir. Absolutely, sir. If you want to answer this first, no issues.
Yes. Paras, please. Paras, if you could unmute, then, or you may alternatively type it here.
Sir, you can first address the question in the chat box.
So, how is it identified whether the promise was false from the inception or on happening of events? Certainly, it's very difficult. It's very difficult, and Supreme Court has acknowledged that how difficult it may be. Because once we are negotiating and we are in a very cordial, romantic relationship, most cases of false promise of marriage would be cases stemming from an otherwise romantic relationship. It's often a case of a romantic relationship turning sort of inimical relationship for whatever reason, of course. So it would be difficult, but then it has to be proved like any other fact. It has to be proved like any other fact, and this is exactly what the Supreme Court has said. For example, if a man was already married, this is just an illustrative sort of a statement that I'm making. A man was already married when he had a fling or an affair with a woman, and while remaining in that first marriage, he promised that he is going to marry. It may be that his promise was false from very inception, though that's not decisive that the previous marriage is a proof in itself, or the marriage is proof in itself that it was hoax. But then there may be. How about the legal implications in and procedural requirements for prosecuting cases involving cyber fraud, particularly those whose question is this? Indira Chakrabarti is asking a question here. Let me first read the question. It's a long question. How about the legal implications and the procedural requirements for prosecuting cases involving cyber fraud, particularly those involving emerging technologies such as deepfake videos and AI-generated content. Additionally, how do these provisions align with international standards on cyber crimes, and what challenges enforcement agencies face in effective implementing these? All right. Yes. True. Legal response may be inadequate. That would be my first part of the reply. Legal response may be inadequate. The law enforcement agencies, public prosecutors, and even the judiciary may lack expertise for effective prosecution of cyber fraud cases and cases involving emerging technologies like deep fake videos and the AI generated content. So capacity building is the key. Capacity building is the key. As far as Bharatiya Nagrik Suraksha Sanhita is concerned, Bharatiya Nagrik Suraksha Sanhita is a technology neutral legislation, and you would agree with me that best legislations are those which are technology neutral. It's a challenge, no doubt. It's a challenge, no doubt, but I don't think that there are separate procedures for offenses of cyber fraud or offenses that involve these technologies and all. There's none. What challenges do law enforcement agencies face? First is that India is still not party to any comprehensive international treaty for cooperation in case of cyber offenses, which are often committed while the accused would be sitting in a different jurisdiction altogether. So a transnational character of these offenses and issues of jurisdiction, they are the major challenges. And as I said, that because they involve very sophisticated technology, so unless and until the police and the law enforcement fluids are also equally capable of understanding and analyzing those technologies, certainly it would be not an effective response to these crimes, certainly.
Thank you, sir.
I hope that's all from the audience and from my side as well. So we can wind it up. So,
Surely, sir, surely. If there's anyone else, we'll just wait a minute for you. If you have a doubt, you can write it in the chat box or open your mic and speak. We'll just wait a minute. That's all. So in that case, I guess we'll move on. So thank you so much, sir, for your insightful participation as a speaker in our certificate course on new criminal laws. Your expertise and valuable contributions have greatly enriched the event. We truly appreciate your time and effort, and looking forward to many more such collaborations in the future. And I'd also like to thank Professor Sonam and Principal Lama from the Sikkim Government Law College team for making this possible. And as always, Dr. Pandey has always been a patron for the legal voice. So thank you so much, sir, for being here.
see you tomorrow.
Surely.
Bye bye. Take care.
All right,
everyone.
participants.
All
So
the best.
we have our third. So see you all there. Thank you so much. So thank you so much, everyone. Thank you, Hemant.